Welcome to the James Wilson Institute and Center on Religion, Culture, and Democracy Zoom webinar titled Parental Rights from the Natural Law Tradition to Skrmetti and Mahmoud, Foundations and Applications, with Professor Melissa Moschella. For those of you listening on the Anchoring Truths podcast, welcome. I'm your host, Garrett Snedeker. We're pleased to feature our guest speaker, Melissa Moschella of the University of Notre Dame. She is the author of the recently published book, Ethics, Politics, and Natural Law, Principles for Human Flourishing. A rich yet cogent articulation of new natural law theory, Professor Moschella's work has been described as, quote, the clearest, most readable exposition and defense of contemporary natural law theory yet to appear by our friend, Professor Robert George. Professor Moschella is professor of the practice in philosophy at the University of Notre Dame's McGrath Institute for Church Life. Her work spans the field of ethics, political philosophy, and law, and her areas of special expertise include natural law theory, biomedical ethics, and the family, especially parental rights. She graduated magna cum laude from Harvard College, earned a licentiate in philosophy summa cum laude from the Pontifical University of the Holy Cross, and received her PhD in political philosophy from Princeton University. Melissa, the floor is yours.
Great. Well, thank you so much, Garrett, for inviting me, and thanks to everybody for taking the time out of your busy day to attend this presentation. So let me go ahead and get right to it. A century ago, in Pierce versus Society of Sisters, the Supreme Court famously stated, "The child is not the mere creature of the state. Those who nurture him and direct his destiny have the right, coupled with the high duty, to recognize and prepare him for additional obligations." This landmark decision declared that parents have a fundamental constitutional right to direct the education and upbringing of their children. Pierce's language echoes the common law tradition, which recognizes that parents are their children's primary educators, that this implies broad authority to direct their children's upbringing, and that this authority is based on parents' natural educational duties. But why does the duty to raise and educate children belong primarily to parents, rather than the state or professional educators licensed and hired by the state? How do parents' duties relate to their rights? And what is the proper role of the state in this arena? In this presentation, I'll address each of these questions, first considering their foundations in philosophy and in the common law tradition, and then offering an interpretation of Pierce, according to which Pierce, building upon Meyer v. Nebraska, should be understood as declaring that this robust common law understanding of parental rights is part of the liberty protected by the 14th Amendment of the Constitution. And then finally, I'll turn to contemporary controversies, particularly Skrmetti and Mahmoud, to consider how this understanding of parents' constitutional rights would apply in these cases. So first, why are parents primary educators? Imagine a society like the one portrayed in Lois Lowry's classic novel, The Giver, where children are taken away from their mothers after birth and then distributed to prospective parents deemed worthy by the rulers. Or think of ancient Sparta, in which male children were removed from their parents' custody at age 7 to be educated communally by public officials. Most of us find these scenarios appalling, because most of us think that parents should be the ones in charge of children's education and upbringing. But why? Why not say that the state is ultimately in charge of children? The answer in one sense is obvious. Parents, not the state, have deep and enduring bonds with their children, and parents, not the state, are the ones who bring children into the world in the first place. The relationship between parents and children is unique. Parents are the biological cause of their children's very existence and identity. This connection makes them uniquely suited to meet their children's needs, especially their need to understand their origins, to navigate the task of identity formation as they mature, and the need to know that they are loved by those who brought them into being. And here I'm talking about the central case of parenthood, which is biological, but I'll discuss adoptive parenthood in a moment. So even if there were no government or laws, parents would still have authority over their children because by nature, They are the ones responsible for taking care of their children. And taking care of children requires making decisions about what is best for them, because children aren't yet mature enough to make those decisions for themselves. Because parents' duties are grounded in the unique personal relationship they have with their children, those duties are theirs. That means the state can't simply absolve parents of their educational responsibility and take over for them. That would be like trying to absolve parents of the obligation to love their children by sending a social worker to hug the children for them, or trying to absolve a Catholic of the obligation to attend Sunday Mass by having a state official go instead. Like the duty to love one's family members or to worship God in accord with one's faith, parents' duty to direct their children's education is a personal duty that can't be transferred to others. Of course, parents can enlist the assistance of others to help them fulfill this duty, but ultimately the buck stops with them. For these reasons, parents' authority to direct the upbringing and education of their children is both primary and pre-political. Parental authority is primary in the sense that it's prior to the state's authority over children, which is subsidiary to that of parents, that is secondary to parental authority and aimed at helping parents fulfill their child-rearing duties. The primacy of parental authority is based not only on the common sense recognition that parents' knowledge and love of their children generally make them much more likely than state officials to know and want what is best for their children, but more foundationally on the fact that parental authority is pre-political in its origins. That is, it's grounded in the very nature of the parent-child relationship, not in any way derived from the authority of the state. This view has deep foundations in the Western philosophical tradition and in the United States legal tradition. John Locke, for instance, argued in his influential second treatise on government that parents have natural duties to raise and educate their children and corresponding authority to carry out those duties. On his view, such authority exists in the state of nature before the formation of political society. Because parental authority is independent of and in no way derived from the authority of the government, even after political society, Locke says that parents, quote, retain a power over their children and have as much a right to their subjection as those who are in the state of nature, unquote. The Anglo-American common law tradition echoes this understanding of parental rights. William Blackstone wrote that parents' duties to maintain, protect, and educate their children, which are the basis of their child-rearing authority, are, quote, laid on them not only by nature herself, but by their own proper act in bringing them into the world. Similarly, American common law jurist James Kent states that, quote, the wants and weaknesses of children render it necessary that some person maintain them, and the voice of nature has pointed out the parent as the most fit and proper person. Now, you might be wondering, what about adoption? Well, adoption is the exception that proves the rule in this regard. Adoptive parents are, of course, real parents who form deep and enduring bonds with their children. But because adoptive parents lack the unique pre-existing relationship with their children that grounds biological parents' natural obligations and corresponding authority, the state requires adoptive parents to be vetted and licensed. And as a prospective adoptive parent myself, I can tell you this is an extremely rigorous and invasive process. And adoptive parents have to make an explicit commitment to take on the child-rearing duties that biological parents have by nature. But once they do take on that commitment, they have the same duties and corresponding rights as any other parent. The fact that we would be appalled if the state required biological parents to undergo this sort of vetting and licensing process before being allowed to have custody of their children, just as we are appalled at the practices in Lowry's The Giver and in ancient Sparta, serves to underscore that it's only common sense to claim that parents' rights are primary and political and pre-political. Thomas Aquinas has a powerful metaphor that helps us understand the nature and basis of parental rights. Aquinas argues that the family is like a continuation of the mother's womb. Just as children need 9 months in their mother's womb to prepare their bodies for physical birth, so too do children need to be educated and raised to maturity within the spiritual womb of the family before they can be born into the larger society as adults, fully responsible for their own actions. This metaphor suggests that the family, headed by parents, has its own natural sphere of authority to carry out the task of raising and educating children. And just as it would be wrong and harmful for the state to intrude violently into a mother's womb, so too would it be wrong and harmful for the state to intrude coercively into parents' sphere of educational authority, unless parents prove themselves to be unfit through genuine abuse or neglect. The spiritual womb of the family, therefore, marks out a sphere of jurisdiction within which parents have the authority to direct the internal affairs of the family community, especially the upbringing and education of children. So what's the role of the state here? Properly understanding the scope and limits of state authority with respect to children requires first having an accurate conception of political authority itself. The purpose of political authority is not to usurp or replace the proper authority of the individuals, families, and other sub-political communities that make up society. Rather, as I argue in my recent book, political authority's purpose is to remedy the insufficiencies of these individuals and groups by serving as an overarching authority with coercive power to coordinate society's members in order to reliably and efficiently provide order, security from internal and external threats, public goods, and an impartial administration of justice. These are the main elements of the political common good, which might be summed up as the conditions that facilitate the pursuit of flourishing by society's members. Now, what's crucial about this account of political authority, and at the heart of what it means to have limited government, is that it recognizes the existence of various layers and spheres of authority within society, which the state has an obligation to respect. There's not only the general authority of individual adults to govern their own lives, but also the authority of families, civic and cultural associations, corporations, churches, and so on, to govern their own internal affairs, relatively free from state intrusion, except when required by the political common good. And so political authority is overarching, but not totalitarian. For the essence of totalitarianism, as Hannah Arendt explains in her seminal work on the subject, is the elimination of all mediating authorities between the individual and the state. And primary among these mediating authorities is the family. As we've seen, the family, headed by parents, has natural pre-political authority to control its internal affairs, especially the raising and education of children. Although children are also under the authority of the state, parental and state authority over children are on different planes. Children are primarily and directly only under the supranational authority of the United Nations through the mediation of the United States government. The layered nature of authority within the political community and the primacy of the family's authority with regard to child rearing suggests an analogy between the family's relationship to the state and the state's relationship to the international community as a whole. Coercive intervention into the affairs of a sovereign state by the international community is usually only considered justifiable either to stop grave human rights abuses or serious direct harm to the international order. Analogously, coercive intervention into the family's natural sphere of jurisdiction is justified only to stop genuine abuse or neglect, non-ideologically defined, or to prevent grave harm to the public order. For instance, if parents are training children to be criminals or terrorists. This view is also echoed in the common law tradition, with the prominent American jurist Joseph Story, for instance, indicating that the state should not interfere with the natural authority of parents unless they are clearly proven guilty of, quote, gross ill treatment. And state courts throughout the 19th century employed this standard. The upshot is that any policy that makes it difficult or impossible for parents to fulfill their parental obligations in line with their consciences is a serious violation of parental rights, and also often of religious freedom, given that many parents see their parenting duties as a sacred trust from God. Of course, these rights are not absolute, but because they are so fundamental, a high bar needs to be met before the government is justified in overriding them. That high bar is effectively captured by the legal strict scrutiny standard, which indicates that the government may only burden certain fundamental rights if it can prove that there is no less burdensome way to achieve a compelling state interest. Now, I believe that this is true not only as a matter of basic justice, but also as a constitutional matter. As I've argued in a recent article in the Texas Review of Law and Politics, there's a strong basis in history and tradition for viewing parents' rights as fundamental constitutional rights that merit strict scrutiny. I don't have time to go into all the technical details of that analysis here. So let me just focus on analyzing Pierce v. Society of Sisters, the landmark parental rights case in which the Supreme Court overturned an Oregon law requiring all children to attend the public, that is, government-run schools, effectively putting all private schools out of business. Oregon's purported reasons for the law included the desire to ensure that children receive an education that fosters their development into patriotic, law-abiding citizens. This is clearly a legitimate, perhaps even compelling, state interest, and the law also has an obvious rational relationship to that interest. So, if the court had really been using the deferential rational basis test, the law ought to have been upheld. However, the Oregon District Court rightly argued that, although educating future citizens is certainly an important state interest, eliminating private schools and forcing all children to attend public schools is not necessary for the state's end, particularly given the lack of evidence indicating that allowing children to be educated in private schools undermines this interest or otherwise causes public harm. And the Supreme Court affirmed the reasoning of the Oregon District Court. So we see that although the legal doctrine of strict scrutiny didn't exist at the time, the reasoning in the decision is effectively applying that rigorous standard, placing the burden of proof on the state to show not merely that the law at issue was related to some legitimate state interest, which it obviously was, but to show that the law was necessary for, that is, narrowly tailored to, the state's compelling interest in educating future citizens, and thus that there was no less burdensome way to achieve that goal. Pierce also gives important guidance regarding the scope and limits of government authority with regard to education, and thus by implication tells us also about the scope and limits of parental rights in education. On the one hand, as the Pierce Court explicitly notes, quote, no question is raised regarding a state's authority to enact compulsory education laws and to regulate education. On the other hand, Pierce also implies that the state's coercive authority in this arena is limited to ensuring that, quote, studies plainly essential to good citizenship are taught, and to forbidding the teaching of anything that is, quote, manifestly inimical to the public welfare. So this is a pretty high bar for coercive state intervention in education. And the reason for this high bar is that, as Pierce famously states, the child is not the mere creature of the state. Pierce thus acknowledges that parental educational authority is prior to that of the state, and that the state should accordingly pursue its educational goals in ways that assist parents in fulfilling their educational duties without usurping parents' authority. This approach is in line with the common law understanding of parental rights that Pierce, together with Meyer v. Nebraska, declared to be part of the liberty protected by the 14th Amendment. Let me just say a brief word here about Meyer, since you can't fully understand what Pierce was doing in isolation from that case. In Meyer v. Nebraska, decided 2 years prior to Pierce, the court had overturned a law forbidding the teaching of foreign languages to grade school children. Although Meyer was focused primarily on the right of teachers to exercise an honest profession, Meyer laid the groundwork for Pierce by claiming that education is, quote, the natural duty of the parent, and that the liberty guaranteed by the 14th Amendment includes the right, quote, to marry, establish a home, and bring up children, along with other privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. So, building on Meyer and adding a more explicit discussion of parental rights in education, Pierce held that Oregon's attempt to mandate public schooling for all went beyond the bounds of state authority because it undermined parental control over education and was not strictly necessary to achieve the state's interest in ensuring that all children have access to an education that will enable them to become law-abiding, productive citizens as adults. Now, the next major Supreme Court case regarding parental rights in education didn't occur until about 50 years later in Wisconsin v. Yoder, in which the court held that an exemption to Wisconsin's compulsory education laws should be made to allow Amish parents to end their children's formal schooling after the 8th grade so that they could educate them at home in skills and values central to the Amish way of life. Applying the strict scrutiny standard, the court recognized that the state had insufficient reason to force Amish children to complete 2 additional years of formal schooling, given that this would interfere seriously with Amish parents' ability to educate their children in line with their religious values, and that the Amish had proven themselves to be a law-abiding, self-sufficient community. Even though Wisconsin's compulsory education laws were reasonable and within the scope of the state's legitimate authority, enforcing those laws against the Amish in this case would have been unjust and unconstitutional because it seriously burdened both parental rights and the free exercise of religion, and was unnecessary for the achievement of the state's interest. Up until Mahmoud v. Taylor, which we'll discuss in a moment, lower courts deciding controversies about parental rights in education tended, however, to sideline Yoder as irrelevant, arguing that Yoder was limited to the unique case of the Amish and had no implications outside of that specific context. But I bring it up here both to show how parents' rights jurisprudence is connected to free exercise jurisprudence, and also to give another more explicit example of the application of strict scrutiny in a parental rights case. Now, before I turn to the application of this philosophical and constitutional argument to contemporary cases, let me first summarize my foundational claims about parental rights. The argument in sum is that because parents have natural and primary authority over their children, the state's authority over children should generally be exercised in an indirect and subsidiary way, that is, through the mediation of parents, in ways that assist parents in fulfilling their responsibility without usurping parental authority. The exceptions to this are of 2 types. One, the state may intervene coercively to protect children's welfare when parents prove themselves unfit through abuse or neglect, non-ideologically defined. And 2, the state may enact certain requirements for civic purposes, for instance, compulsory education laws, to ensure all children can receive at least a minimal level of education, enabling them to be law-abiding, productive citizens. But the state is justified in enforcing such requirements against parental objections only when this is truly necessary for a compelling state interest, as captured by the strict scrutiny standard. Thus, the Amish rightfully received an exemption from an otherwise reasonable compulsory education law because enforcing this law against them was not necessary for the achievement of the state's interest. On the other hand, if there were, for instance, parents who objected to teaching their children basic literacy and numeracy, the state could, I think, justifiably require them to allow their children to receive this kind of basic education, because such knowledge is arguably plainly essential to good citizenship, as the Supreme Court put it in Pierce, and would therefore meet the requirements of the strict scrutiny standard. So now let me turn to some applications. In particular, what does all this mean when it comes to Skrmetti, Mahmoud, and similar contemporary cases? First, let's consider U.S. v. Skrmetti, which challenged the constitutionality of a Tennessee law prohibiting hormonal and surgical interventions for pediatric gender dysphoria. The specific question before the Supreme Court was whether the law violated the Equal Protection Clause of the 14th Amendment, and the court held that it did not, arguing that the law did not require heightened scrutiny because it does not classify based on sex or any other suspect category. Instead, the law classifies based on age and medical use, and such classifications do not trigger heightened scrutiny. And so, applying rational basis review, the court upheld the law, arguing that given the risks and uncertain benefits of the interventions in question, the state had a rational basis for restricting them. For our purposes here, though, I'd like to analyze an aspect of Skrmetti that the Supreme Court did not consider. That is, the plaintiff's argument presented at the lower court levels that the law in question was a violation of their parental rights because it prevented them from directing their children's medical care. So, is it a violation of parental rights for a state to ban puberty blockers, cross-sex hormones, mastectomies, and other interventions for pediatric gender dysphoria, even when parents believe that these interventions will be beneficial to their children? I would argue that the answer here is no, and that the Supreme Court would and should have still upheld the law in question, even if the parental rights issue had been explicitly considered. Because the arguments and evidence presented by the court in defending the law would also, I think, have been sufficient to show that the laws in question don't actually violate parental rights. As the court argued, Tennessee and states with similar laws are simply exercising their well-established authority to regulate the practice of medicine for the sake of public health. Indeed, as one amicus brief noted, there's a long history in American criminal law and common law barring interventions, such as castration, that risk or cause permanent mutilation or loss of bodily function, regardless of consent. And while it's true that the Model Penal Code does make an exception for physicians administering a recognized medical treatment, what counts as a recognized medical treatment has itself been understood by judges to depend on the state's regulatory decisions. Further, as the court noted in Skrmetti, whatever one's view is regarding the merits of medical and surgical interventions for gender dysphoria, it's hard to plausibly claim that there's anything close to a medical consensus on the appropriateness and safety of these interventions, especially in pediatric cases, given that the UK, Sweden, France, Finland, and other countries have largely stopped providing these interventions for minors with gender dysphoria after evidence reviews highlighted their significant, often irreversible, health risks and uncertain benefits, with some studies even showing that mental health problems and suicidality were actually exacerbated by the interventions, as well as concerns about the inability of minors to meaningfully consent to such irreversible changes to their bodies, often including permanent sterility. Further, WPATH and many US medical associations and practitioners have been criticized for making recommendations that are not evidence-based, and even for actively suppressing research that is contrary to their recommendations. Most famously, Dr. Olson Kennedy, head of the country's largest youth gender clinic, has refused to publish the results of her NIH-funded study because the findings indicate that puberty blockers did not lead to mental health improvements, but did cause physical harm, such as lags in bone growth and fertility loss for some patients. So given the current state of the medical evidence, there's ample reason for states to judge that hormonal and surgical gender transition should not count as a recognized medical treatment that is exempt from the usual legal prohibition on causing permanent bodily harm to others, even with their consent or with the consent of a proxy, such as parents. So while parents have rights to choose among legally recognized medical treatments for their children, no one, not even adults deciding on their own medical treatment, has a right to demand that a medical intervention deemed unsafe by the state be made legally available to them. Finally, what about cases in which parents want to exempt their children from being exposed to certain controversial books or lessons about sexuality or gender in school, such as Mahmoud v. Taylor? In Mahmoud, the Supreme Court vindicated the rights of Maryland parents who wanted to opt their elementary and preschool children out of lessons involving storybooks that promoted controversial views regarding gender and sexuality. Relying primarily on Yoder, the Supreme Court applied strict scrutiny and ruled on pre-exercise grounds that parents have a right to such opt-outs, because forcing their young children to be exposed to these lessons undermines parents' ability to direct their children's religious upbringing and is not necessary for the state's basic educational goals. The court also highlighted the coercive nature of public schooling, recognizing that although in principle, parents are free to fulfill the compulsory education requirement by sending their children to private school or by homeschooling them, in practice, these alternatives are not feasible for many parents due to lack of resources. Now, I believe that the free exercise arguments that the court relied on in Mahmoud are sound, but I think that the court could and should have gone further, because the free exercise ruling leaves the rights of non-religious parents unprotected. And as Justice Kagan and others noted during the oral argument, there are many non-religious parents who object to the sorts of lessons at issue in the case. Further, in my view, this was a missed opportunity for the Supreme Court to clarify and correct the inconsistent, confused, and often erroneous parental rights jurisprudence that has been predominant in lower courts over the past half-century. As I've argued in a forthcoming Notre Dame Law Review article and in my amicus brief on behalf of the petitioners in Mahmoud, lower court decisions like Mozart v. Hawkins, Brown v. Hot, Sexy, and Safer, Fields v. Palmdale, and Parker v. Hurley have repeatedly failed to recognize parents' rights to the sorts of opt-outs that were sought in Mahmoud. And these decisions were based on both flawed free exercise jurisprudence and on misinterpretations of the true scope and strength of parents' constitutional rights. Mahmoud corrects the flawed free exercise arguments of these lower courts, notably by resurrecting Yoder and insisting that Yoder's reasoning is applicable to other cases outside the unique context of the Amish. So this is an important victory. But unfortunately, Mahmoud did nothing to correct the flaws in these lower courts' understanding of parental rights, which rest on a historically inaccurate, weak, and narrow interpretation of Pierce. These lower court decisions interpret Pierce weakly insofar as they argue that infringements on parental rights only warrant rational basis review, and they interpret Pierce narrowly insofar as they argue that Pierce merely forbids the state from forcing all children to attend public schools. As the Ninth Circuit put it in Fields v. Palmdale, on this view of Pierce, the right of parents to direct their children's education, quote, does not extend beyond the threshold of the school door. However, a historically informed reading of Pierce, understood in light of the strong common law tradition of respect for parental rights that Pierce, following Meyer, declared to be part of the liberty protected by the 14th Amendment, reveals that parental rights in education are both broad, extending well beyond the schoolhouse door, and strong, requiring strict scrutiny. Key to this historically informed understanding of Pierce are 8 state Supreme Court cases in the 19th and early 20th centuries, each of which dealt with parents seeking the right to opt their children out of particular aspects of the public school curriculum. In 7 out of 8 of these cases, decided largely on the basis of common law, the parents won. And this is true even though the lessons parents objected to were not typically about controversial intimate matters. They were lessons in things like singing and geography. And even though in most cases the parents' objections were not religiously grounded. This is relevant because, as I've argued, Meyer and Pierce should be interpreted as declaring that parental rights, as understood in the common law tradition, are part of the liberty protected by the 14th Amendment. And these state cases give clear evidence that, under the common law, parents had broad rights to direct their children's education, even within the public schools and even after compulsory education laws were enacted. So while Mahmoud was an important step in the right direction, in my view, the court didn't go far enough because it didn't address the parental rights question head on, and so failed to take this important opportunity to correct and clarify the confused, inconsistent, and historically inaccurate state of parental rights jurisprudence. Now, there's much more that I could say here, both about these cases and about other cases regarding parental rights that are currently making their way through the lower courts. But I've already covered a lot of ground very quickly, so I want to stop here to make sure that there's plenty of time for questions. Thank you.
Thank you. Thank you, Melissa. Again, to our attendees, please utilize the Q&A feature at the bottom of your screen to submit your questions in writing. We'll acknowledge you after we formed a queue when it's your turn to speak. If you'd like to ask your question anonymously, just make sure to note that in the Q&A function, and I'd be more than happy to read your question on your behalf. Okay, well, I can see that Hedley Arcus would like to jump right on in with his question. So I'm going to recognize
Melissa, that was so good, so clear. Thanks so much for that. Just the when friends talk about parental rights, they seem to forget the way the founders understood that for every liberty we could mention, there's a form of license. Every liberty could be directed to a rightful or wrongful end. So what shouldn't surprise us that we can talk about parental rights at the same time, talk about the obligation of the law to intervene. Some of our friends think that the parental rights were simply substantive due process. They came along in Myers versus Nebraska. Our late friend Nino Scalia derided them in that way. But there was a letter a while back in the Wall Street Journal from a man who said who's being threatened with the loss of custody over his children in California because he's seeking counsel for children and undergoing confusion about their gender. He was assuming that the federal government would come to his aid. Now, I take him to be, I take those parental rights to be as part of the Constitution as though we're in the text now. And I take it that the federal government could indeed intervene. I just want to get your sense of that. Let me just pile on one other thing. In the matter of Skrmetti, there was there's an appeal here to the judgment of the legislature balancing things, but there could not have been appeal to the deeper, inescapable truth that these surgeries cannot, in fact, change sex. They're predicated on a falsehood. So I was wondering, at some point, would you invoke that argument along the way, Melissa? But just a couple of points here, but along with my thanks.
Yes, thank you very much, Hadley. So yeah, on your first point about the unfortunate parent in California whose parental rights, in my view, are being violated by the state. I think absolutely that this is an unconstitutional violation on the part of California, and that it's within the scope of the federal government through the court system to intervene there. And that's, I mean, so, this relates to your point about, where these rights come from, whether they're, kind of substantive due process rights, quote unquote, there has to be some constitutional anchor for them. Meyer and Pierce were, inclined to anchor it in substantive due process. That was the favored jurisprudence of the day. I think perhaps a better anchor might be the Privileges or Immunities Clause, or maybe even the Ninth Amendment. But regardless of what you think the kind of best anchor is, I think that the basic point remains that this is a natural right understood as such by the common law, and that places basic limits on the authority of the state in this sphere. And that, I think, is the essence of what was being recognized in both Meyer and Pierce. On your question about Skrmetti, I agree that the court, it didn't need to go into kind of deeper arguments on the merits about this issue, because there was kind of ample evidence that the law was sufficient for the requirements of rational basis review. But I agree that there is a question about reality here, about what it means to be male and female, and about whether it's possible to change one's maleness or femaleness. And there is a biological and metaphysical fact about this, that it's not actually possible to change that once we actually understand both the science and the metaphysics in question. I think together with that, there is an argument that even under strict scrutiny, the state has a compelling interest in acknowledging the reality of biological sex, and in preserving children from interventions that will permanently take away their fertility, given the obvious interest that the state has in the reproduction of society over time. I would argue that even under strict scrutiny, the kinds of laws that Tennessee and Kentucky have passed restricting these kinds of interventions would still pass muster under the highest level of judicial review.
Right. Good.
Great. Next question comes from Rich Moss. Are families pre-political, or are they an example of a way that we as humans are inherently political?
I don't think that's an either or. I think that's a both and. So what I mean by pre-political is that families exist, and would exist even if there were no political authority to acknowledge them, right? Just as marriage is a moral reality that exists, and would exist even if there was no state to officially recognize it as such. And the family is an outgrowth of marriage. So at the same time, the idea that we are familial creatures, right? Creatures made for and fulfilled by good family relations is an indication of our social nature, which then ultimately points to our nature as political beings who need to be in a well-ordered political community in order to thrive. So the family is a community in its own right and would exist without the state, but families can't really flourish unless they are part of a larger political community that is well-ordered.
Again, the queue is open if anybody would like to submit their questions. Melissa, what would you say is contained in your new book that, from a philosophic perspective, is the most challenging claim that, let's say, a natural lawyer that wants to hold to an understanding of parental rights as rooted in tradition, but instead, as kind of Hadley was making clear in his question, the tradition sort of runs very, very strongly into the first principles of moral and practical judgment.
Not sure that I quite understand the question. Can you clarify what you're
So
getting at there?
The idea that I'm trying to get at is when our parental rights tradition, deference to the work of the hard work of parents who are called to so many different obligations in the rearing of their children, deference to their decision making runs into what are the natural law commands, which may not be nearly as expedient perhaps as viewing deference to the parental responsibilities.
I see. Yeah, so I mean, I think that's where we get to questions about these kind of layers of decision-making authority, right? So I think the context for this is recognizing that while there is an objective moral truth, there's also contestation about that moral truth within the political community. And so then the question is going to be uncontested questions about what's best for people in general and what's best for a particular child in a particular circumstance. Who has the relevant decision-making authority? And the argument is that it's the parents who have that decision-making authority. That doesn't mean they're always going to get it right. But it does mean that unless they are proven unfit, or unless the decisions that they're making kind of cross the lines into genuine abuse or neglect, then we need to defer to that, even if in our own best judgment, we disagree with what the parents in this case think is the best for their children. So it's a question about authority, which then allows for parents, yes, to make some mistakes, but the argument is systemic in that children will arguably be better off when we allow parents that deference rather than when we empower the state to second guess all of the decisions that parents make.
We have an anonymous question. Are you aware of any litigation currently pending in federal court that you believe will be especially important for us to watch, assuming on the parental rights front?
So yes, there are several interesting cases pending. So there's
Or
A
state courts.
case.
Sorry, there's a follow-up from the anonymous questioner. Also, state courts as well,
Yes, yes.
if federal suits aren't coming to mind.
Yeah, well, so there's one there's an appeal to the 10th Circuit in a case called Wales, which is a case about Wales v. Jeffco is the full case name. This is a case about the county's policy, school policy of rooming students in kind of overnight school trips on the basis of declared gender identity rather than on the basis of sex. And in the case, you basically had a child who was on an overnight field trip and kind of discovered on the trip that she was placed with a biological male, sharing the same room and I believe even the same bed. So this kind of raises obvious privacy issues for the child, but also, you know, obvious parental rights issues. So that's one to watch. There's another one. It's Vitsitsaki versus Skanitalis. I don't know how to pronounce either of those parts of the name, which I believe is also making its way through the courts. This is a case regarding a kind of so-called secret social transition of children in the public schools, where the child declares a different gender identity in the school, and the school, while failing to inform the parents and even actively taking steps to hide this from the parents, facilitates that child's gender transition in school, giving them a different name, different pronouns, sometimes even different clothing that they change into at school. So there's another case about that. That's similar to the Eau Claire case that the Supreme Court failed to grant cert for in the past term. But I'm guessing that one of these secret transition cases, of which there are a number at state levels, is going to eventually make its way up to the Supreme Court.
Excellent. We have a little bit more time. So if anybody would like to come forth, you have at least a couple of more minutes. I'll just ask one more burning question that I had before we maybe have one or two more from the audience. When in your research on parental rights, our parental rights tradition, and sort of as the common law treatment like has intersected with emerging, for example, like blue state enactments, when did you realize that we were sort of on a collision course with tradition and then the like introduction of technologies that truly presented the kind of questions that the tradition became a lot more difficult to either analogize or address? I'm talking maybe about like IVF in addition to trans, in terms of the discussion.
Right. Well, I mean, so the common law tradition is kind of presuming a classic biological model of parenthood, and is kind of rooted in that argument that because parents are the biological cause of their child's identity, that they're responsible for bringing that child into the world. They have the responsibility and the corresponding authority to maintain and educate their children. That gets complicated in scenarios where you can kind of separate out the different aspects of parenthood, as with IVF, when you have, say, third party IVF with, quote unquote donor sperm or donor eggs being used, that separates the biological parentage from the intended parents who end up in these cases being the legal parents. But that's a complicated scenario, and at the same time, we've seen cases where sperm donors were sued for child support, and they were required to offer it. So the law is a kind of muddle here, because there's still the traditional understanding where, you know, biology is the basis of parental rights, but our technologies have enabled us to kind of blur these lines. Surrogacy is another issue, which is very complicated legally, because biologically, in the old days, right, you would have to be the genetic mother of the child in order to be the gestational mother of the child. But now with gestational surrogacy, there are separations that occur there, and there are different laws in different states about who the default legal parent is in those sorts of cases. I mean, in my view, this all points to the need for much better regulation of in vitro fertilization, largely with a view toward respecting the rights of the children involved in this process, but also when it comes to surrogacy, with respecting the rights of the women, who are often left quite vulnerable in these circumstances.
Great. Just one more. Actually, Hadley Arcus would like to get back in. So last question from Hadley, and then I'll be turning it over to Jillian Barr with the CRCD.
Got a question by Richard Moss. You made me go back to Alan Bloom on this. Aristotle reminds us that the polis is as much an emanation from nature as the family. And he says in that remarkable passage that the polis, the polity, is prior in the order of nature to the family. That is, he understood that people can have sex even when governments break down. Sex is prior, but what constitutes the family, what gives names to the family, may be bound up with the law. So your comment maybe go back to this line from our old friend Alan Bloom, where he said, it is only in the context of the law that a man can really imagine that the offspring from his loins can people the world. The law that gives names to families and tries to ensure their integrity is a kind of unnatural force and endures only as long as the regime of which it is the part. Just an old teaching about this. It may not be pre-political, that the notion of the encompassing laws may always be there if there's an awareness in the beginning that parents may do something that violate their responsibilities, and the law you have the sense that of the imminent presence of the law, the moral logic of the law attending the family as well. Just to throw something else for us to ponder.
Yes, well, far be it for me to disagree with Alan Bloom, but I think, I mean, I understand the point that he's trying to make there, but I do think there's still the natural moral law that sets the structure of marriage and family, even if, hypothetically, there were no positive law to recognize it. Now, I agree that in the order of things, and this is what I think Aristotle was getting at, the family will only flourish fully if it is incorporated into a well-ordered political community, and a well-ordered political community would therefore have laws to recognize families, right? So I think that the relationship is reciprocal there, and which is prior, I think, depends on what you mean by prior. So I think Aristotle is using prior in reference to the political community to mean this is what brings us to our fullness. This is what we need to have the full flourishing of individuals and families and some political communities. But there's another sense of prior, which is the way that I'm using it, where there is a more basic natural moral law that would exist, and that would give the basic structure of the family and the basic rights and responsibilities of parents with respect to their children, even in the absence of any political authority.
You put it well, Melissa. You put it well. Thank you.
Thank you.
All right. Jillian Barr of the CRCD will close us out. Jillian?
Yes. First of all, thank you so much, Melissa, for an incredible webinar. And to our attendees, we appreciate you joining us for this joint webinar hosted by the James Wilson Institute and First Liberties Center for Religion, Culture, and Democracy. We will be continuing these joint CLE webinars, so please stay connected with us through our email newsletters, through JWI and the CRCD, so that you can see the October CLE date as well as November. And we look forward to hearing you guys and your feedback from the CLE webinar. Thank you for joining. Have a good day.